All right, good morning, Counselor. Are you able to hear the court okay?
I am. Good morning.
Good morning. Let me go ahead and call your case at this time. We are on no record because it's a dismissal hearing, but this is cause number DC 216695, Hollywood Trucking LLC et al. Versus ABC Record Service et al. Counsel, can you state your name and let me know who you represent in this action?
Christine Malera, and I am counsel for defendant ABC Record Service.
All right, and what is the status of this case? When I saw it, I remember this from a long time ago. I'm showing it's settled, but what's the update?
So we did settle this case back in May, and we exchanged settlement agreements, and all that's finalized. As part of the settlement terms, the plaintiff was to provide the title to the vehicle that was the basis of this lawsuit to the defendant, and then we would provide the settlement funds within, I believe it's a week. And we have the check ready to go, but we never received the title, and I have not been able to reach counsel for the plaintiff in 6 months. I've tried emails, calls to his office, calls to his cell phone, calls to assistants. I haven't been able to get in touch with anybody. I hope he's, doing okay. I looked to see if maybe something had happened, because he wasn't responding and no one from his office was responding. But I haven't been able to locate him.
All right, so you need the title pursuant to the settlement that you all entered, correct?
Correct. And we have the settlement agreement. So if counsel comes around with the title, we'll pay the settlement funds, immediately. And we'll have to request a new check because the check is no longer valid. But I think if anything were to arise with the settlement agreement, any issues that we'd be able to work that out. There'd be a breach of contract action. What we would like is to have this case dismissed and closed down so that our client can, close its file and then open it back up if and when
Okay,
we hear from
okay,
counsel.
okay. I think that is more than reasonable. This case will be dismissed for want of prosecution. I will sign an order to that effect today. And assuming the settlement agreement does not get worked out, then I guess you can decide whether or not you wish to pursue some type of breach of contract claim, which will be a new claim. But I will sign a dismissal order today.
I appreciate that. Thank you, Your Honor.
Okay. Thank you so much. Have a good week.
You
Bye-bye.
too. Bye-bye.
All right, good morning. Can you hear the court okay?
Yes, ma'am.
Okay, all right. Going to go ahead and call your case right now. We are on the record in case number DC 23-10038 in the matter of the change of the name of Kendra Ivana Gray. Can you let me know your name?
Yes, ma'am. It's Kendra Ivana Gray.
Okay, and how would you like to be referred to today? Or what are you seeking to change your name to?
Kenneth.
Kenneth Gray, okay?
Yes.
All right, Mr. Gray, you have a petition for a name change. Let me
Yes,
just
ma'am.
take a look at your petition that has been filed. You're representing yourself, is that correct?
Yes, ma'am.
Okay. And you're requesting a gender marker correction because you are undergoing treatment now to transition from female to male. Is that correct?
Yes, ma'am.
Okay. And have you uploaded with the court the appropriate background criminal history information that the court needs to review?
Yes, ma'am. It should have been sent over from when I did the fingerprints and everything.
Okay, I have it here. Let me check one other place. Okay, and let me just take a look at your health letter here from Dallas Counseling Treatment Center. Is that correct?
Yes, ma'am.
Okay. All right, and you have uploaded a order here and you have not been convicted of a felony. Is that correct,
That is correct.
Mr. Gray? Okay. All right, and the name that you are seeking, the current name is Kendra Ivana Gray, and you are seeking to change that name to Kenneth Ivan Gray. Can't read this morning. Is that correct?
Yes, ma'am.
Okay, all right. I will grant the relief that has been requested. I will sign a copy of the order. The order will get uploaded today. So by the close of business today, Mr. Gray, you ought to be able to review the order and pull it down and make any copies you might need. Is there anything further that you need from the court regarding this case?
No, ma'am. Thank you so much.
Okay, thank you so much. Good luck to you, okay?
Thank you. Have a great day.
You too. Bye-bye. All right, good morning, council.
Good morning, Your Honor.
Morning.
Good morning, Your Honor.
Good morning. Let me go ahead and call your case. We are on the record in cause number DC 22-10058, Erica Graham versus Terrence Heights Owners Association, Inc. et al. May I have the parties to briefly announce on the record? Let me know your name and who you represent.
Good morning, Your Honor. This is Jim Selder, and I represent Erica Graham as co-counsel with the NACO law firm, and Mr. Baker will also make his appearance on behalf of Ms. Graham.
Yes, Ryan Baker from the NACO law firm, here on behalf of plaintiff Erica Graham.
All right, thank you. I guess we have someone else joining. Looks like Mr. Sirachi. Mr. Sirachi, I just called this hearing, the matter that is set at 10 o'clock. And I just took announcements. If you wouldn't mind announcing on the record your name and who you represent in this action.
Hi, this is Jason Charles Shiroki. I represent the movement, Eric Verdugo and Terrace Heights Owners Association, Inc., the counter defendants in this case.
All right, thank you. I understand this matter is set for a motion for leave this morning. Is that correct?
Yes, Your Honor.
Okay, I'm hearing a little bit of feedback. If you're not talking or not objecting, if you'll just put yourself on mute, because that will be better for me and the court reporter that are here in the courtroom this morning. I'll go ahead and hear from the movement with respect to their motion for leave. I know there's been a response in opposition filed to that. So after I hear from the movement, then I'll let the other side respond.
All right, may it please the court. Hi, good morning, Your Honor. We have this motion for leave, which is essentially a motion to allow the counterclaim to stay and be alive, even though the counterclaim is beyond the original scheduling order. I wanted to first address to the court why the movements have diligence. With regards to this motion, there were some things that were outside of our control, meaning that if Ms. Graham did not disclose accurately the creditors and the outstanding bills when she left as the property manager and as the president of Terrace Heights, we may not be in a position to know what information that she didn't give us. And just citing a few pieces of information we didn't receive so the court can understand. We didn't understand, the board was told prior to Ms. Graham leaving Terrace Heights that the Roto-Rooter bills were paid. And in fact, even in this lawsuit, it's alleged that a lot of the expenses were because of expenses that occurred between January and March of 2021. They were Roto-Rooter expenses. Since that time, approximately 8 months ago, Roto-Rooter sued Terrace Heights, claiming that another $40,000 was owed, that when Ms. Graham was president of the association, that a total of about $110,000 in invoices were received from Roto-Rooter, and about $70,000 of those invoices were paid. Roto-Rooter is just one example. Another example can be the banking records. For whatever reason, Ms. Graham decided when she was no longer president of the Terrace Heights Owners Association, Inc., she decided to go ahead and close out the Pay HOA bank accounts. That was the means by which the members would pay into the association, and it was also the means by which payment requests would be approved by the association. Because Ms. Graham did this while Ms. Graham periodically had no problem being the only signer on the bank accounts when the bylaws normally would want the treasurer to also be a signer on all the checks. By doing this, Ms. Graham made it more difficult for us to find certain pieces of information. One of the most salient pieces of information is what happened to the first $100,000 insurance check. When you look at the banking records, you'll never see a check closer to April the 7th of 2021 coming into a bank account for $100,000. The closest thing that we could find is about $45,000 or $55,000 going into an enterprise account. We've since bothered the insurance carrier a few times, and we've learned that that check was deposited at a Chase bank account, although we don't know whose Chase bank account it is. All we know is that Terrace Heights Owners Association, Inc. did not have a Chase banking account. when the other side, because defendants originally approached us about filing an agreed continuance back in September, we agreed and moved for the continuance under the belief that we would eventually have the depositions, that we'd eventually have more facts fleshed out, because typically I don't like to accuse someone of mishandling more than $40,000 without asking them some questions under oath. We were always planning on having the mediation occur after the depositions. And so when the court told us in October that the case was not going to be continued and that the parties needed to mediate next, in order to satisfy the needs of the court, we went to the mediation before securing the depositions. And almost every other world, I think Mr. Rabe and I would agree that we would have liked to have had opposing counsel or worked out something to where the parties had a little more certainty as to who was testifying as to what. With regards to the motion for leave and the reason why we had to wait on certain issues, frankly, you know, I could be sanctioned if I just loosely assert things. We found out later on that the owner of Unit 151, when she sold her unit, she later told us that the Terrace Heights Owners Association, Inc. Did nothing to repair her unit. And that's one of the central units that's involved in the insurance claim. There's approximately 8 units where between $20,000 and $40,000 worth of damage was alleged as a result of the, I don't know if this court calls it Uri or the great winter storm of February. I guess it's not winter, but February 2021. But 8 units were more substantially harmed than the rest. And so there are 8 units where they had insurance claims of about $20,000 to $40,000 in the estimated cost to rebuild, which was provided by a third party by Engel Martin. And so when we learned that Unit 151 did not have the rebuilding done that was recommended and required by insurance, that Ms. Graham oversaw, because she signed a document stating that within 1 year of the date of loss, that she would have the property restored back to its original condition. That's just one of the obligations under the insurance contract. And so we didn't find out about that, and we weren't capable of finding out about that before. In terms of diligence, we put on a suit and tie. We met with Truist Bank because they're local. They rejected us. This was last November. We then went through the third-party discovery, and while we're waiting for third-party discovery, I was in Florida, and so I thought, hey, might as well go ahead and try Enterprise and Seacoast since they have a presence out there. Enterprise basically became Seacoast Bank. But I can also show the court several correspondence where we separately emailed people through their LinkedIn contacts once we found a contact name associated with the old bank accounts that the plaintiff conveniently closed down and made inaccessible for us. And so as a result of not having the $100,000 insurance check in the front and the back and not knowing where that went, we really preferred to have an answer to that question prior to filing the counterclaim. But once the court made it pretty clear that the continuance was going to be denied, we thought as an abundance of caution, because technically the association is basically 66 different families that each own a condo unit. And so these 66 families need an answer with regards to some things, Your Honor. And so I realized that the other side might be frustrated that we didn't file a counterclaim earlier. But once the deposition schedule went off schedule, we really didn't want to file it before we had confirmation of some facts. And so confirming from the owner of Unit 151, she lives in California now, but we're hoping she'll testify via remote deposition at the trial, that once she confirmed recently that her unit was not rebuilt and that Ms. Graham had promised her $25,000 and that same $25,000 wasn't earmarked for repairs when Ms. Graham left, which incidentally was after a year after the date of loss, which was February 14th versus February 22nd. But those are our main reasons for the motion for leave, Your Honor. And I'm happy to reserve my time to either answer questions the court has or issues that Mr. Baker brings up.
All right, I'll hear a response at this time.
Good morning, Your Honor. This is Jim Souter on behalf of Ms. Graham. The Ryan Baker's firm has been prosecuting Ms. Graham's claims to this point. This lawsuit was filed on August the 22nd in an attempt for Ms. Graham to recoup some of the expenses she advanced on behalf of the association. So within that time period, there's been ample opportunity to pursue whatever discovery that Mr. Chiarocchi suggests that needed to be done. There was a docket control order, Your Honor. It's very clear about what your expectations were for the parties. It was entered in on November the 30th of last year. It required that any new causes of action, any new claims be asserted no later than August the 1st or August the 7th of this year, Your Honor. This counterclaim was filed on November the 6th, or excuse me, November the 6th of this year. Therefore, it's very untimely and therefore very prejudicial with respect to the claims asserted here. You've already heard just before Thanksgiving a motion for leave to move or continue the trial schedule based on a potential for Mr. Ryan Baker's firm to go to trial. You reset it for January the 22nd, but the initial case status conference or the docket control order was not amended. It is therefore untimely and therefore very prejudicial, Your Honor, and therefore we object to any counterclaim being filed and going forward. In addition, Your Honor, attached to this or as a part of the counterclaim, there is a request for a jury fee or a jury trial. That is, it was currently set on as a bench trial. That pleading was again not only filed late with respect to your DCO, but it also was filed less than 30 days before trial. So under Rule 216, there was no timely request for a jury trial, and for some reason it's listed on the docket currently, if you look it up, as a jury trial. So we object to that from that perspective also, Your Honor. But there's no verified motion for leave to try to prove up these facts. Nothing that suggests before the court why these things could not have been fleshed out, and there's no current discovery motions pending before the court. There's nothing that suggests that this could not have been addressed or was a problem for going to trial. So for those reasons, Your Honor, we request that the motion for leave to file the counterclaim be denied and that the case remain on the docket as a bench trial.
All right, any response, counsel?
Yes, Your Honor. Very briefly, first I want to emphasize the fact that since Ms. Graham was the president of the board of the Terrace Heights Owners Association, Inc., and because she got to choose which lenders that she dealt with, she was the only person that had the signing authority and the ability at these banks to get over the information quickly. So once she decided, I think it was April 15th or May 15th, that she was going to shut down the pay HOA accounts, we were out of luck. I tried the same email contacts that she had through the Terrace Heights Condos at gmail.com email address, contacting the same people and letting them know, hey, I'm the attorney. And we tried a few different versions of this where we introduced the folks at Classic Property Management and Mr. Verdugo and so on. And we had a sort of credibility gap that they said, well, go and do it through third-party discovery because they weren't quite sure who we were. And so although the other side is saying that these issues could have been resolved in discovery, if Ms. Graham didn't keep the bank accounts open, and if Ms. Graham then didn't turn over those materials to Classic, which she was required to turn over, both as a fiduciary, as a property manager, and as a former president, that she actually was being paid to do this as well. So she had different reasons why she was required to act with diligence and to provide all the information that she had available, and she didn't. And one of the difficulties in taking over an organization when there's a change in the board of directors and so on is that you have to refamiliarize yourself with your various vendors and creditors so that they'll deal with you. We've taken a little time to do that. Each property management group, sets up their own bank account, and for them, moving forward is very easy. But for the purposes of going back and determining, why the first $100,000 insurance check was not deposited into a Terrace Heights account was very baffling. It looks like the second check, the check for $373,000 that was around June the 30th of 2021, that was deposited in a Terrace Heights account. But then that one has, I believe, the signature of Jim Graham, of Miss Graham's husband, on it instead. So we have questions like this that we think are best answered in a deposition. But that's one of the reasons why we, normally would try to verify those facts when you have papers and documents that are out of place, that are not the fault of the defendants. In this case, the plaintiff had the control, the plaintiff had the power, of these random 66 families that own condo units. where would they even figure out how to go and research some of this? You know, they've asked to look at our books and we've showed them our books, but some things are just simply beyond our control. Ms. Graham could have retained a copy. I imagine if we looked at Ms. Graham's computer, she probably does have a copy of a lot of these documents, but these documents were not turned over to the Classic Property Management, especially that check for $100,000, and they weren't turned over to us in response to any discovery request. And unfortunately, even the third-party discovery from the banks didn't have everything that we wanted. We're still going and beating them up over finding out if there's any other information on some signature cards. But that's what we're stuck with, Your Honor. And the other part of this motion is that we asked if for some reason the court was inclined to deny the motion, that the court would at least sign an order recognizing that the court didn't think that these were compulsory counterclaims and that these claims could still be brought by either other members of Terrace Heights or Mr. Verdugo or the association itself later, if the court thought that there was a timeliness issue or an issue of unfair surprise and prejudice. What we contend is that since Ms. Graham, Julian Nicole announced ready for trial a few weeks ago and said that he was ready to try this case, that with or without this counterclaim that he would be able to try the facts. It's still the same case. Either way, we've still pled on the defense side that we have an offset. We've still pled unclean hands, which would take away their claim for quantum merit. We've still pled breach of fiduciary duty. So whether the court thinks that it was Ms. Graham not disclosing that she got 1 to 5% cash back on some of the cards that she used, if that was a breach of fiduciary duty, or if this court thought that maybe Ms. Graham breached a fiduciary duty when she prioritized payments to herself over payments to Roto-Rooter. There are a lot of different reasons why this counterclaim is valid. But I can promise this court that if we had more information that was voluntarily given and which Ms. Graham was required to give us, then we would have filed this sooner. And I'll reserve my time for any questions.
All right, with respect to the motion of the defendants to allow late filed counterclaims and also a jury demand, the court does deem it untimely and it will deny the request. And I am signing an order to that effect today. Are there any questions for the court?
Yes, Your Honor. I submitted a proposed order that also denied it, but then at least noted that this wasn't a denial of any of the claims on the merits in case any of the parties wanted to bring their own claims, et cetera. And so I'm hoping that the court will.
Well, the order that I'm signing says that the counterclaims are dismissed without prejudice.
Okay.
Okay.
Thank you, Your Honor.
All right. Any additional questions? If not, that concludes our hearing.
Thank
All right.
Your Honor.
All right,
Thank you.
gentlemen, take care.
Thank you.
Bye now.
Bye-bye.